Okay, good afternoon, ladies and gentlemen. My name is Judge Law, and we are going to begin with our misdemeanor first appearance calendar. These are cases in which individuals were recently arrested and booked at the Fulton County Jail. Soon after the arrest, the cases have been formally accused by the Solicitor General or the prosecutor for this particular court. So when I call your case, I will let you know what is your new case number, the charges that have been brought against you, to appoint counsel where necessary, to also set a bond, and to give you a new court date if required. Ms. Bridgewater, good afternoon.
Good afternoon, Your Honor. Your reset date for the SAP calendar is going to be June the 17th.
Okay, thank you so much.
You're welcome.
So with respect to bond, some of you may qualify for what we call a signature bond. It can either be done through the jail or through pretrial services. In either event, if you are granted a signature bond, you would have to make sure you comply with the conditions of the bond. You won't have to pay for it today, but if you violate the conditions, that bond can be revoked, and the next time you would have to pay for that bond out of your own pocket. For those of you who do not qualify for a signature bond, you may possibly receive either a cash bond or a surety bond. In that particular case, you will have to pay for the bond either out of your own pocket or through a bonding company. For those of you who are still here within the next 2 weeks, your next court date will be June 17th at 9 a.m., and that will also be a virtual proceeding. So those of you who plan to attend, please make sure you get a Zoom link from the clerk's office. If you're a defendant charged with one or more misdemeanor offenses, you have the right to remain silent. Anything you say in open court, your statements can and will be used against you in the treatment of your case. You have a right to an attorney. If you cannot afford one, one will be appointed to represent you. Courtroom 2, who do we have, please?
Position 7, Judge. Ms. Laney.
Okay. This is Denise Shalija Laney, accused of simple battery and battery from January 18th, 2025. Her accusation number is 25CR 3148G. Ms. Laney, you've been advised of your right to remain silent, and your attorney is going to be Mr. McLean. Any priors, Mr. Howard?
7. On probation in Clayton County for simple battery. On probation for ag assault, simple battery, criminal damage to property, second degree, and a 2020 obstruction conviction.
Is
That's
the
it.
ag assault also in Clayton?
Yes.
Okay, thank you. Ms. Harrison?
Yes, Your Honor. This incident occurred on January 18, 2025. College Park officers were dispatched to 24510 National Highway, room 235, in regards to an active fight. When they arrived, they met with the victim, Ms. Shantaria Ramey, who stated that her and her daughter, Ms. Shakira Reeves, were visiting a friend in room 235 for her daughter's birthday. While in the room, the defendant came in the room and began fighting with Ms. Ramey's daughter. Her and her friend broke up the fight, and the defendant was put out of the room. Officers asked Ms. Ramey why the pair were fighting, and she said she was familiar with the defendant because the defendant and her daughter used to date. After that first fight, Ms. Ramey had her daughter leave the hotel room, and while she was still in the room with her friend, the defendant came back into the room with two other females and two other males who had firearms and began fighting Ms. Ramey again. Ms. Ramey did not fight back at the time because she was concerned for her safety due to the number of people attacking her. At the time, the friend that she was visiting contacted the police, and that prompted the defendant and the other people she brought into the room to leave. And officers on the scene observed scratches and visible bleeding from Ms. Rainey when they met with her on the scene. She was shown a photographic lineup and was able to point the defendant out and identify her as the person that attacked her. The state's recommendation in light of the defendant's prior offenses and criminal history is a $4,000 surety bond. We're asking for $2,000 on each count, no contact with the victim at all. That's Ms. Shontaria Ramey, and stay away from the incident location and the victim's residence. No drugs, weapons, or alcohol while out on bond, and completion of an anger awareness course. And we will sound for Ms. Ramey at this time, though we were not able to contact her. That'll be all for the state, Your Honor.
Okay, Shontaria Ramey, if you are present, please unmute and start your video. All right, Mr. McLean.
Your Honor, apparently this case from January apparently may have been a hold while she has been in Clayton County taking care of all her cases there. She tells me that it was a violation of probation. So hopefully there's been counseling, there's been incarceration, and hopefully this was something that she'd get credit for if it acted as a hold upon her. We would ask the court to consider a signature bond, Your Honor. She is 23, high school education, and works in restaurants. She's local. Her dad's got a 678 number, and her address is local here at 30311. There's no problem in staying away from everyone. Thank you.
Thank you. On the simple battery is 1,000. On the battery is 1,500. The total bond is 2,500 surety. No further contact with Shontaria Ramey, and stay away from the building at 2501 Old National Highway in College Park. She's not allowed to return to that location, and to have no contact with Ms. Ramey and stay 200 yards away from her. And she's also to not consume any alcohol, no illegal drugs, and not own, possess, or have any firearms near her. Next court date is June 17th. Thank you.
Okay. Position 11, Mr. Parker, Ms. Parker. Wait.
Could you give me that name again, please?
Parker.
Harper. Okay. I heard Harper.
Number 11, Parker.
I'm so sorry. Okay, Parker. I was wondering where Harper came from. Okay. Thank you, Paul. Okay, Jordan Mackenzie Parker is accused of criminal trespass under accusation 25 CR 3151Y. Mr. Parker, this incident dates from June 3rd, yesterday. And he's been advised of his rights, and his attorney is going to be Ms. Tucker. Mr. Howard, any priors?
It's fifth arrest on probation, dumping waste under 500 pounds in volume. It's 24 CR 001 473Y. 2025 failure to appear. 2025 possession of drug related objects. 2025 possession of drug related objects NOLO.
That would be the same case then. Okay. Mr. Scirocco, good afternoon. And I'm sorry. Yes, Mr. Scirocco. Good. Yes, sir.
Thank you, Judge. Yes, as you stated, this incident took place yesterday. This is at 741 Morosco Drive, Northeast Atlanta. The core, Lindbergh, in reference to a criminal trespass is what law enforcement responded to. The officer found the defendant sleeping on the side of the apartment complex near the front entrance side wall area. The officer spoke with the leasing agent at the location, Carol Kirkland, who explained that the defendant had been issued previously a criminal trespass warning, preventing her from coming to the location. She returned anyway in violation of that, and officer placed her into custody at that time. With the previous criminal trespass convictions I'm seeing from 2022 and 2025 also, in addition to the FDA that pretrial stated, I also see one from 2022. The state's recommendation, given the risk of reoffense and failing to appear here, is $1,000 surety, social worker visit for BHET, stay away from the core at Lindbergh, at 741 Morosco Drive, Northeast Atlanta, and no drugs, weapons, or alcohol while out on bond.
Right, Ms. Tucker?
We have no objections to the state's recommendations. Ms. Parker currently is homeless. And so we would, of course, ask for the social worker visit. And she is currently unemployed, so we would request the lowest possible surety in this case. And after speaking with her, she is more than willing to stay away from the incident location. So otherwise, we have no objection to the state's recommendations. Thank you.
That was $1,000 surety, correct?
That's correct, Judge.
That's $1,000 surety. Stay away at the core at Lindbergh. And next court date is June 17th. I don't think she has any other open cases presently, so.
Oh, I do see a 23 CR 0017773C, which is a battery. Let me double check and make sure I have the right individual.
Okay. I don't see that, but.
I can advise. Give me 15 seconds. Never mind. I was mistaken about that.
All
Thank
right.
you.
Next case, please.
Position 10, Ms. Ochoa.
This is my phone. What's the last name?
Ochoa. And who represents Ms. Ochoa? Ms. Tucker?
Yes, Your Honor.
Okay. This is State versus Valerie Ochoa, accused of a fray from June 3rd, 2025. Case number 25 CR 3147D. Is she a cross defendant or a co-defendant?
It was a dual arrest, Judge.
Okay, with Davia Sedilio?
That is correct.
Okay. Is there anyone else involved in this case?
Not to my knowledge.
All right. Deputy, do you have the Yvonne Davia Sedillo there as well?
Yes, I do.
Two.
He's here. You want to come up to Judge?
Yes, please. One can remain standing. Thank you. All right. So Valerie Ochoa is accused of a fray and fighting from June 3rd, 2025 under accusation 25 CR 3147D. Ms. Yvonne Davia Sedilio is also accused of a fray from June 3rd, 2025, case number 25 CR 3161D. Both of you have been advised of your right to remain silent, and Ms. Ochoa is represented by Ms. Tucker, and Ms. Davia Sedilio is represented by Ms. Maureen McLeod. Mr. Howard, do you have the GCIC, if any?
We're gonna do a tour first. 6 adult, 2017 failure to appear, 2013 criminal damage to property, dead docket. Who is the other one?
Position 2, Yvonne Davila Sedillo.
Hold on.
Position 2.
While you're doing that, Mr. Howard, could you repeat what
Oh.
year that FTA was?
2017.
Thank you.
Just hold on for a minute.
All right.
I have no history for that individual, Judge.
And what's the state's recommendation for both cases?
For both cases, the state is recommending signature bonds through pretrial services, along with no further contact with one another. Stay away from the Villas del Mirasol at 700 Holcomb Bridge Road in Roswell, and no drugs, weapons, or alcohol while out on bond. This incident took place June 3rd, 2025 at 700 Holcomb Bridge, Old Holcomb Bridge Road. Excuse me, that's the correct address, the Villas de Mirasol. Law enforcement responded to a physical disturbance call. Upon arrival, made contact with Miss Ochoa, Valerie Ochoa, who had visible injuries, including scrapes and scratches to both of her legs and arms. And Miss Ochoa also had a scratch on her forehead and a knot. She stated she was attacked by Miss Davila Cedillo in the parking lot after being tricked into coming to the location under the impression that she was meeting her husband's best friend. The officer then met with Miss Davila Cedillo, who explained that Miss Ochoa had been texting her boyfriend about having sexual relations, and she told the defendant she wanted to talk woman to woman. Miss Davila Cedillo advised that Miss Ochoa started the physical altercation by scratching her first in the chest area, and then they both engaged in mutual combat. She sustained Miss Davila Cedillo multiple scratches to her chest area, scraped to the bottom of her chin as well. There were no witnesses on scene to corroborate either account. They both stated that the other one started it, and that they wanted to press charges against one another. With that, signature bonds through pretrial services, no further contact with one another, stay away from the incident location, and no drugs, weapons, or alcohol while out on bond.
Ms. Tucker and Ms. McLeod, do either of your clients live at that location?
No, Your Honor.
So Miss Ochoa lives on Holcomb Bridge Road, but she lives at 2600. So I believe it is the same community. Maybe it's not the same community.
Well,
Okay.
my client doesn't live there. That's why I was shaking my head. She lives in Chambly.
Okay, maybe it's just the same road name. So no objection to
one is Old Holcomb Bridge Road, the other one's Holcomb Bridge Road. It's not a very imaginative.
It's not the same, so
Yeah.
no objections, Your Honor.
Okay. With regards to Ms. McLeod, your client, Yvonne Davisa Dio, is going to be a 2,500 signature bond through pretrial services, level 1. No further contact with Valerie Ochoa after today. To stay 200 yards away from the entire neighborhood at Villas del Marisol, which is 700 Old Holcomb Bridge Road in Roswell, Georgia. And no illegal drugs, no alcohol, no weapons, and to attend and complete 2 anger awareness classes. If she gets arrested again, or if she doesn't comply with these conditions, her 2,500 signature bond will be revoked. With regards to Ms. Ochoa, same requirement. It's a 2,500 signature bond through pretrial services, level 1. To stay 200 yards away from Ms. Davia and also from the Villas del Marisol at 700 Old Holcomb Ridge Road in Roswell, Georgia. And if the boyfriend allegedly lives at the Villas del Marisol, well, I guess he will have to decide who he wants to visit. But I hope that what you both are experiencing, that he is completely worth it. Best of luck. Next court date will be sent to your current addresses.
Thank you, Your Honor.
Got position 5, Judge, Ms. Hebelberger.
Oh, Ms. Chansey, which case do we have for?
I think the one that just ended, Your Honor. My client has very limited English. I was able to speak with her using Google Translate.
Oh, y'all should have mentioned it. I just kept going on because nobody stopped me. So, does your client understand what I just said?
She made it, Your Honor, her English is very limited. However, I was able to ascertain from her that she's the mother of 4 young boys that she shares with this
That's not the point.
person.
Ms. McLeod, if your client needed an interpreter, then due process requires that I use the interpreter.
Yes, I think she would need to be told what you decided, Your Honor.
Okay, Deputy, please don't release Ms. Davia. We have to go through the process with the interpreter. But in the meantime, who do we have?
Position 5, Ms. Hebelberger.
Okay. Heather, Ms. Chansey, I'll be right with you. Sorry about that. I did not realize. Okay, Heather Hepperberger is accused of 2 counts of theft by taking from June 3rd of this year. Accusation number 25 CR 3149C. Ms. Hepperberger, you've been advised of your right to remain silent, and your attorney is going to be Ms. Tucker. Any prize, Mr. Howard?
Third, 2015 DUI.
Okay, thank you. Miss Harrison?
Yes, Your Honor. On June 3rd, officers were advised via phone report of an incident at 16305 Deer Point Court. The call was in reference to a theft, and the victim was Miss Laura Howes. Officers contacted her via phone, and she explained what happened. She advised that she had a friend at her residence on May 27th and identified the friend as the defendant, who had met with her at a restaurant on May 27th, and the defendant was drunk and followed her home. They stopped at a Lowe's on the way home so Miss Howes could pick up some turf, and the defendant ended up spending the night because she was too intoxicated to leave. The next morning, when Miss Howes and her friend left her residence around noon to go their separate ways, she got into her car and noticed that her phone was missing. She went back into her residence to look for it and found the tracking device that she kept on the back of her phone was on the countertop, but there was no phone on the countertop. She went back outside to see if her friend, the defendant, may have taken the phone, but she was already gone from the location. On the morning the morning that the phone went missing, Ms. House recalled a conversation with the defendant where the defendant informed her that she was going to meet her father off of Holcomb Bridge Road and they were going to Orlando, Florida for a convention. So when Ms. House couldn't find her phone, she went to a gas station to call a friend to see if they could track it. And they did track her phone. The last location that the phone was pinging from was Holcomb Bridge Road. And that's how Ms. House concluded that the defendant had taken her phone. She tried to call the phone several times that day, but no one picked it up. Her friend also tried calling and got no answer, and the phone was turned off at some point during that day. Ms. Howes also reported to officers that a wallet containing money and bank cards was also missing, and she provided a photo of the defendant to the defendant's social media to officers. They were able to confirm the defendant's identity and to get a description of the vehicle that the defendant was driving the night prior to the phone being taken. Through investigation, officers were able to confirm that the defendant actually was at the Miss Howe's house the night before and leaving the location. And they called her after confirming her whereabouts. And she informed them that she had picked up the Miss Howe's phone when Miss Howe's dropped her belongings in Lowe's, and she placed the phone in a mailbox. And the phone had been there since she placed it into the mailbox. And even her father had asked about the phone. Officers were not able to determine which mailbox the defendant was referring to, but they concluded that it was probably her father's. We did speak to the victim today. She stated that her and the defendant were friends. She confirmed the events in the warrant, and she stated she just wanted her phone back. She had to pay $250 to get a new phone and $100 to get a temporary phone from Walmart. She does not wish to have any contact with the defendant. The state's recommendation here is a $2,000 surety bond. That's $1,000 on each count. We're asking for no alcohol, drugs, or weapons while the defendant is on bond, a stay away from the incident location, and no contact with the victim. And we'd like to sound from his house at this time, and that'll be all for the state, Your Honor.
Laura Hiles, if you're on Zoom, this is the time to unmute and start your video. Okay. Ms. Tucker?
Yes, Your Honor. We are requesting a signature bond for Ms. Pepperberg today. She is a 35-year-old Atlanta native. She has a bachelor's degree in journalism. She's employed at as a doctor's office as a medical assistant. She's been there for over a year. She has a very limited criminal history, and she has no prior failure to appear. Her father has lived at the same residence for years, where she was raised, and she has ties to the community. She's very likely to appear in court. And because of her criminal history, a signature bond will be appropriate in this case. So that's what we are requesting.
So, Ms. Harrison, other than the cell phone, what else did she take?
The wallet is believed to have been taken, but it's not been recovered, Your Honor. It had $200 in it and credit cards and a bank card.
Okay. On the first count theft by taking is $1,500. Second one's $1,000. It's a $2,500 signature bond through pretrial services level 1. No further contact with Laura Hiles to stay away from 16305 Deer Point Court in Alpharetta, Georgia. No illegal drugs, no alcohol, no weapons. Ms. Hepperberger, you're required to report to pretrial once a month. And if you get arrested again, or if you fail to show up in court, or you violate any of the other conditions of the bond order, this 2,500 signature bond will be revoked. Your next court date will be sent to your current mailing address. Make sure it's updated with the clerk's office. Thank you.
Got position 6, Mr. Hunt.
All right. Deputy, we'll have to go back to position 2 because that defendant needed the interpreter services.
Okay, we can go back to position 2.
All right, I'll finish with Mr. Hunt and then we'll go to Antonio Martinez Hunt is accused of criminal trespass from June 3rd, 2025. Accusation 25 CR 3150Y. He's been advised of his rights and his attorney is Mr. McLean. Any priors?
For Hunt, 32. On probation, theft by receiving, acquiring license plate for purpose of concealing identification. Possession of marijuana. We got a Cobb County theft by taking probation, 2024 probation, 2023 probation, 2016 obstruction conviction, 2012 probation, 2012 FTA. That's it.
Thank you. Yes, Ms. Chansey.
Yes, I would like to start. This is
not this one. It's going to be the one right after this.
Oh, okay. Thank you.
Thank you. Ms. Harrison?
Yes, Your Honor. On June 3rd, officers were dispatched to 425 10th Street Northeast, Unit 1, in reference to a criminal trespassers. They made contact with the unit's neighbor, Ms. Jennifer Fraser, who advised that she believed someone was inside her neighbor's apartment. The primary resident, she informed Officer Ms. Barbara Lamons, was currently in the hospital. Her and Ms. Lamons' son, Mr. Michael Lamons, were looking after the property. Ms. Fraser stated that the window on the north side of the residence was open. Ms. Fraser did open the residence for officers with the key she had. They entered and they heard the shower running and observed a black male inside the apartment. The male was identified as Mr. Hunt and he was detained. He was found to not be a resident or authorized visitor of the location. He informed officers that he entered through an unlocked door and he entered the residence in an effort to get clean and take a shower. Mr. Michael Lamons, the primary resident's son, arrived on scene and stated that he did not know the defendant and he did not give the defendant any permission to be inside the residence. We did speak to Mr. Lamons today. He stated that he and his mother do not know the defendant. He confirmed the events in the warrant and stated he believes the defendant broke in the night before and stayed overnight. They are not sure if a passport was stolen from the house, but they have not located one since the defendant was inside the house. He stated that he is looking out for the house until his mother gets out of the hospital. They want no contact with the defendant, and he wants him to stay away from the residence. The state's recommendation here is a $1,500 surety bond, no contact with the victim, a stay away from the incident location, no drugs, alcohol, or weapons while out on bond. A social worker visit to assess any residential challenges. And Your Honor, we do have Mr. Lamons on call today, so we would like to sound for him in the event that he would like to be heard, and that'll be all for the state.
Okay. Mr. Lamont, if you'd like to unmute and start your video.
So I'm struggling to get the video to work.
So mute your screen until your video comes on. All right, Mr. McLean.
Your Honor, thank you. Mr. Hunt is 36 years old. He has a reliable mail service through PAD. We have called PAD to see about the housing and to assist with that. He asked the court to consider a signature bond. That FTA may be pretty old if it is an FTA at all.
Okay.
He's, let's see, he is definitely local. His contact information is local, the phone numbers, etc.
I've got a Lakewood location. Is that his current address or previous address? What are we talking about?
That's where PAD put him up, but we've been in touch with PAD to see where they could house him next.
Okay, thank you. Bond is going to be set at Mr. Lamont. Have you figured out your video? Okay. Please unmute. All right, raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
I'm going to issue an order requiring Mr. Hunt to stay away from your location and have no contact with you. Anything else? By the way, what's the name of the apartment complex?
Park Place Manor.
Park Place Manor. So he'll be
Yes.
required to stay away from the entire complex, including the parking lot, sidewalks, and so forth.
Yes.
Anything else?
And I mean, I did my best to go through the apartment and see if anything was stolen. It's hard for me to know without mom there, but I'm 100% sure the passport was stolen because I know where it was the day before. The neighbor also saw it the day before, sitting out on mom's counter, and
Okay.
I'm afraid that's been sold for identity theft.
All right. Thank you, sir. Bond is set at 2,500. It is a surety bond. No further contact with Michael Lamont to stay 200 yards away from the entire apartment complex at Park Place Manor, which is at 425 10th Street. And no further contact with Jennifer Fraser and Michael Lamont. Next court date is June 17th. Mr. McLean, your client has a probation hold, 25 PV 001143.
Thank you.
Your Honor, after the Spanish interpreter, can position 1, Miss Beatty, go?
Yeah, all right. Let me do the Spanish interpreter case first. Oh boy. All right, Ms. Chansey, if you please raise your right hand, do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
I do, Your Honor.
You. I'd like to call for Miss Senora Yvonne Davila.
Yvonne, I'm sorry, Yvonne
Yeah,
Davila.
Sadillo. All right. Could you ask Miss Sadillo if she understood what I had told her before?
Señora Sadillo, ¿entendió lo que le dijo la jueza anteriormente?
Un poco, no todo.
A little, not everything.
Right. If she ever finds herself in this situation and she doesn't understand the judge, she should interrupt and let the judge know.
Si alguna vez se encuentra en una situación similar en donde usted no entienda lo que un juez le diga, usted debe interrumpirlo y avisarle al juez.
Okay.
Okay.
Your case number is 25 CR 3161D. You're accused of affray fighting on June 3rd, 2025.
Su caso es el 25CR3161. Y usted tiene cargos por una disputa, por pelear una pelea, y eso ocurrió el 3 de junio del 2025.
You have a right to remain silent. Anything you say in open court about the facts of your case, your statements can and will be used against you. You have a right to an attorney, and Miss Maureen McLeod is your attorney.
Usted tiene el derecho a guardar silencio todo lo que diga en un tribunal público sobre los hechos de su caso. Sus declaraciones pueden ser usadas en su contra. Usted tiene el derecho a ser representada por un abogado y la señora Maureen McLeod es su abogada.
Was it Mr. Scirocco? Oh, yeah.
Yes, Judge. This was mine.
Just very briefly, please.
Sure. And I just want to confirm before I proceed any further, the other individual, Ms. Ochoa, does not need an interpreter.
Yo quisiera confirmar si el otro individuo, la señora Ochoa, no necesita un intérprete.
She did not.
Okay.
I spoke with her.
Sounds good. This incident took place on June 3rd, 2025 at 700 Old Holcomb Bridge Road in Roswell, which is the Villas del Mirasol.
Muy bien, este incidente ocurrió el 3 de junio del 2025 en el 700 de Old Holcomb Bridge Road en Roswell, que es las Villas del Mirasol.
Law enforcement responded to a call and made contact with both the defendant and Miss Valerie Ochoa.
La fuerza del orden respondió a una llamada y se contactó con el acusado y la señora o señorita Valerie Ochoa.
Both of them were observed to have visible injuries. Miss Ochoa had scrapes and scratches to her legs, arms, and her forehead, as well as a knot.
Ambas de ellas tenían lesiones visibles. La señorita Ochoa tenía rasguños en las piernas, en los brazos y la frente, lo mismo que un chichón.
The defendant sustained multiple scratches to her chest area, as well as a scrape to the bottom of her chin.
La acusada sostuvo rasguños múltiples sobre el área de su pecho, lo mismo que un rasguño en la parte baja de su mentón.
The two had gotten into a fight at the location over potential infidelity issues relating to one of the partners involved.
Las dos habían comenzado una pelea sobre un potencial caso de infidelidad, problemas de infidelidad relacionados con una de las partes involucradas.
Both the defendant and Miss Ochoa wanted to press charges against one another. There were no witnesses and no primary aggressor could be determined, so they were both arrested.
Ambas, la acusada y la señorita Ochoa, querían presentar cargos en contra de cada una, pero no hubo testigos, no hubo un agresor primario que pudiese ser determinado, entonces ambas fueron arrestadas.
The state's recommendation for this case is a signature bond through pretrial services, no further contact with Valerie Ochoa, stay away from Villas del Mirasol at 700 Old Holcomb Bridge Road in Roswell, and no drugs, weapons, or alcohol while out on bond.
La fiscalía recomienda para este caso una fianza bajo firma a través de los servicios previos al juicio, no tener ningún contacto alguno con Valerie Ochoa, mantenerse distanciado o distanciamiento perimetral de Villa del Mirasol en el 700 de Holcomb Bridge Road en Roswell y se prohíbe el uso de drogas, armas y alcohol mientras esté libre bajo fianza.
Miss McLeod, you agree, yes?
Señora McLaren, usted estuvo de acuerdo, ¿cierto?
Yes, Your Honor, I do.
Sí, su señoría.
Mr. Villa, you can sign up for your bond. Your bond amount is 2,500.
Señora Villa, ¿puede usted registrarse por su fianza con el monto de $2,500?
You don't have to pay for the bond today, but you must comply with the conditions of the bond.
Usted no tiene que pagar la fianza hoy, pero usted sí debe cumplir con las condiciones de su fianza.
If you violate the conditions, your bond will be revoked.
Si usted no cumple con los requisitos, esta fianza va a ser revocada o cancelada.
No further contact with Valerie Ochoa. You're not to communicate with her in any way, form, or manner.
No debe tener contacto alguno con Valerie Ochoa. No puede comunicarse con ella de ninguna manera y de ninguna forma.
You have to stay away from the entire apartment complex or neighborhood called the Villas del Mirasol at Old Holcomb Bridge Road.
usted tiene que estar distanciada del complejo de departamentos o vecindario llamado Villas de Mirasol, que está la calle Holcomb Bridge Road.
No illegal drugs, no alcohol, and no weapons.
Queda prohibida el uso de drogas, alcohol y armas.
Your next court date will be sent to your current mailing address.
Y su próximo día de comparecencia ante el tribunal será enviado a su dirección actual.
You are to complete 2 anger awareness classes with pretrial services while you're out on this bond.
Usted debe completar 2 clases de control de la ira a través de los servicios previos al juicio mientras usted esté libre bajo fianza.
Does your boyfriend live at Villas del Mirasol?
¿Su novio vive en Villas del Mirasol?
You cannot go there. He can decide if he wants to come visit you, but you cannot go there. Understood?
Usted no puede regresar ahí. Él puede venir y visitarla a usted, pero usted no debe regresar ahí más.
Thank you.
Gracias.
All right. Deputy, do we need the services of a Spanish interpreter for anyone else in courtroom 2?
No, Judge, that was it.
All right.
All right. Well, thank you, Your Honor. Have a good evening.
You too, Ms. Chansey. Thank you so much. I hope you feel better.
You're welcome. Thank you.
All right. Take care. Mhm.
We
All
go to position 1, Ms. Beatty.
Yeah, we're going to go to Ms. Beatty at Autumn Beatty at ACDC. Ms. Beatty, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney. If you cannot afford one, one will be appointed to represent you. Presently, your attorney is going to be Mr. Michael McLean. Do you see him on the screen? He's waving his hand. Do you see him on the screen? Okay. Your case number is 25 CR 3145C, accused of criminal trespass from June 2nd, 2025. Any priors, Mr. Howard?
No.
Okay. First arrest?
Yes.
All right. And Ms. Harrison, is this the
Yes, Your
one?
Honor.
This the one at Desert Creek someplace?
Yes, Your Honor. Desert Circle Apartments is
All right.
Regency Park Desert Circle Apartment
Desert Circle.
68 is Regency Park Apartment Complex.
Okay.
Yes, on June 2nd, officers arrived at the incident location and met with Ms. Carlita Williams and Ms. Beatty, the defendant, who were in a verbal altercation. When officers arrived, Ms. Williams stated that the defendant was recently criminally trespassed from the above location, which implies the actual apartment complex. And she stated that Ms. Beatty was threatening her life and that Ms. Beatty was a girl with whom her son had dealings with, and she showed up to his residence, which is the incident location, repeatedly, knowing that she had been criminally trespassed by the apartment complex. The defendant informed officers that she had arrived there to meet with Mr. S. Williams, which is Miss Williams' son, and she was invited over, and she was also going there to inquire about a pregnancy test. She stated that she did know that she was criminally trespassed from the above location, but she thought it was okay because she believed that she was invited there. We did speak to Ms. Carlita Williams today, and she stated that the incident location is her son's residence. She does not live at the residence. She came over there to bring her son some groceries, and when she arrived, the defendant was damaging the screen off the window. She told the defendant to stop, and she informed the defendant that she was not supposed to be on the property, and the defendant began to cuss and scream at her and threaten her. She did inform us that the defendant has been stalking her son for the past 3 weeks, and she comes to the property at 4 and 5 o'clock in the morning, banging on the door, disturbing the neighbors, and that is also how the criminal trespassing came about through the apartment complex. In light of the defendant's limited criminal history, the state does believe that there are some residential challenges here. Our recommendation is a signature bond through pretrial services. We're asking for a stay away from the incident location. no contact with the victim, Carletha Williams, or her son, Mr. S. Williams, no drugs, weapons, or alcohol while out on bond, and a social worker visit to assess any residential challenges. We'll sound for Ms. Williams at this time, and that'll be all for this.
What does S. Williams stand for?
I give me
That's
one
what the
second.
warrant did not say. Okay.
Yeah, I didn't see it. I didn't see it on the report either, but I might be able to find
Mr.
it.
McLean, do you know Romeo's
Spencer. His name is Spencer, Your Honor. I'm sorry.
Spencer?
Spencer.
All right, is Kenethia or Spencer on the Zoom? Kenethia or Spencer Williams? All right. Mr. McLean.
Your Honor, we would ask for a signature bond's first arrest. She's been in Georgia several years. We have a social worker here. If there's any problems with housing, we'll talk to her about that. She's been a manager at an automotive repair place, and she's been a personal consultant prior to that, Your Honor. Like I said, she's 24, has a Lithonia address.
I think you need that social worker visit imminently. Bond at $1,000 surety bond. No further contact with Kenethia Williams and Spencer Williams. Stay away from the Regency Park apartments, and she'll need a social worker visit. Just based on her demeanor and actions, I'm really concerned. No illegal drugs, no alcohol, and no weapons. Thank you.
Thank you.
Next court date is June 17th.
Thank you, Your Honor. Bye-bye.
I got position 4, Mr. Haddock.
We have Laura Hiles on Zoom. Ms. Hiles, if you want to unmute and start your video. That was position 4. Laura Hiles? Yes? No? Okay. Eddie Haddock Jr. is accused of criminal trespass and violation of certain rules at a bus, rail, or station from June 2nd, 2025. Mr. Haddock, you've been advised of your right to remain silent, and your attorney is Mr. McLean. Your accusation number is 25 CR 3146C. Any priors?
27. 2023 ag assault, possession of a firearm during the conviction. 2020 failure to appear. 2019 trespass conviction. 2017 probation. 2015 probation. 2015 trespass conviction.
Thank you. Ms. Harrison?
Yes, Your Honor. On 6/13/25, the defendant boarded a MARTA bus and was seen brandishing a knife, and he was detained subsequently. MARTA officers confirmed his identity to be Eddie Haddock and confirmed that he had been trespassed from on MARTA property on August 18th of 2023. The state's recommendation in light of the defendant's criminal history is $1,000 surety bond, a stay away from all murder property as he's permanently banned, no drugs, weapons, or alcohol while out on bond. And that'll be all for the state, Your Honor.
All right. Mr. McLean?
Your Honor, my client lives here in Northwest Atlanta. He's a graduate of McNair High School. He has a 2-year college degree in Associate of Arts in Audio Engineering. So it's musician sort of oriented and audio oriented. He has worked mainly as a cook in a restaurant locally. And we would ask the court to consider the lowest possible bond, including a signature bond, if that is possible.
Okay. It's 500 on each count. It's $1,000 surety to stay away from all MARTA property, including trains, buses, stations, their facilities, and so forth. He's under a permanent ban from the use of any MARTA services and provisions. So he's not allowed to be on a bus or a train or a station. Next court date is June 17.
Got position 15, Mr. Thomas.
You repeat that.
The state versus Henry Thomas, accused of simple assault, family violence. Are you Henry Thomas?
Yes.
Okay. Your case number is 25 CR 3157J. Mr. Thomas, you've been advised of your right to remain silent, and your attorney is Ms. Maureen McLeod. Miss, Mr. Howard?
14, 2025 failure to appear, 24 DUI conviction, 23 probation, 22 disorderly conduct conviction, 2009 theft by deception, theft by taking no load.
Thank you. Mr. Scarapa?
Thank you, Judge. This took place October 1st, 2024. Law enforcement responded to 970 Mansell Road in Roswell. It's the Walmart in reference to a domestic dispute. Upon arrival,
I'm sorry, you're muted.
Thank you. Apologies. I had to come in for some tech issues today and out of my usual environment. Upon arrival, officer spoke with the victim in this case, Miss Jean Thomas, who explained that the defendant, her son, had requested she meet him at Walmart so they could get some clothing for a job interview. She explained that while at Walmart, the defendant got angry and pushed her near one of the checkout aisles. Ms. Thomas advised that the defendant then left the business, laid in front of her vehicle, threatened to kill her, and kept opening and closing her driver's side door before leaving in his vehicle. A witness, Ms. Shanique Williamson, observed the defendant yelling at Ms. Thomas when she came over to help. Walmart's surveillance video showed the defendant placing his hand on Ms. Thomas's shoulder, then rearing back with his right hand and lunging towards her as if he was going to strike her. The video showed her throwing her hands up in defense and stepping backwards, clearly in anticipation of being struck. The defendant admitted that he was with the victim at Walmart on the date of the incident and that there was a verbal altercation. When advised that the officer observed a simple assault here, when he reared his hand back, the defendant replied, "But I did not hit her." The defendant was positively identified through his driver's license photo and looking at the Walmart video footage, and a warrant was issued for his arrest. As mentioned, he has that 2025 FTA. We have spoken with the victim in this case. She confirmed she's the mother of the defendant. The two do not live together. She confirmed the events in the warrant, denies hearing the defendant threatening to kill her, and stated that the defendant has not been violent with her before, and that he has been in jail in a different county since this incident, and they've been talking while he's been in jail. She states she's not in fear of the defendant and is okay with having contact. We're asking for no further contact. The fact that this took place in public against one's own mother is disturbing. That with the 2025 FTA, he presents the risk of failing to appear as well. As such, the state's recommendation is $1,000 surety for him to complete FFIB, have no further contact with Jean Thomas, stay away from her home and work, and as well as the Roswell at 970 Mansell Road in Roswell, the Walmart, and no drugs, weapons, or alcohol while out on bond.
All right.
And we would ask to sound for her. She may be on the Zoom.
All right. That would be Miss Jean Thomas. Ms. Thomas, if you're on Zoom, if you want to address the court, you can unmute and start your video.
Did we get the right number?
All right, Ms. McLeod?
Yes, Your Honor. I had the opportunity to speak with Ms. Thomas, and she tells me that her son is absolutely not violent. She said they had an argument. She was not the one who called the police. She was quite put out that they had called the police. She said there was some woman at Walmart who called the police. She absolutely denies anything about him threatening to kill her or any such thing. She says her son has lived with her from time to time on and off. He's 50 years old and he's not violent and she's not had any incidents with him. She said he was a little upset. He probably was just having a bad day and they were arguing, but he did not pose any threat to her whatsoever. She was surprised that the police officers came. She said they drove with her back to her home to see if her son was there and all of that. that, but she says she has been in constant contact with him and she does wish to have contact with her son, and he's not any kind of threat to her. He has no violent history on her. He does have some priors, but none of it is violent based on what I heard. And I believe the only reason why he had a FTA was that he was locked up at the time. So I'm going to ask a signature bond for him, Your Honor. And the court can condition that to no further violent contact with his mom, but I think it would be bad for her, and she's the alleged victim, not to have contact with her son. She tells me she's not tech savvy and she would have had an issue coming on the Zoom, but she certainly is in her right mind, and we had a fairly significant, lengthy conversation about what happened. And she clearly remembers what happens and denies that there was anything about her son lying down and saying that about killing her and all of that. That she absolutely denies.
I know,
One,
I know he got an FTA from 2025, and that disqualifies him from a signature bond for pretrial. It's going to
I
be
believe you, Your Honor, he was locked up at the time. That's my understanding. In a different county.
It's a
and then,
$5,000. Yes, Mr. Skiroko?
yes, if I could just respond very briefly. It looks like that disorderly conduct conviction from 2022 stemmed from an original arrest where he was charged with felony terroristic threats and acts. That was ultimately dismissed, but the court should know that. And
Did it involve mom?
not to my knowledge, Judge. And I just as well, I think the intervention of a third party, the fact that a third party felt they had to intervene, speaks to the scariness and seriousness of the situation.
So noted, Mr. Skiroko, and I've also taken the fact that this occurred allegedly in October 2024. As I was saying, he doesn't qualify for a signature bond to pretrial because of the FTA, but his bond is going to be a $5,000 signature bond through the jail. He is to have no further violent contact with Jean Thomas. He may return to live with her or at least just communicate with her, but he cannot engage in any physical or verbal altercations. And quite frankly, he doesn't deserve a shopping trip to Walmart. He should take her for a shopping trip and pay for everything. But in the meantime, he's going to put his money to good use. Within 30 days of being released, he will be enrolled in a domestic violence intervention program. These are 26 classes that he must attend and complete at his expense. At the end of the program, I expect him to present the certificate of completion, which must be filed with the court. Today is June, so this would be December. So it has to be filed with the court no later than February 1st, 2026, excuse me.
Got position 9, next judge, Mr. Minaj.
Thank you.
Thank you, Your Honor.
What was that position number again? I'm so sorry. I must be getting really old.
Number 9.
9, thank you. The Tucson doesn't disagree with that. All right. Madison Niles Munaji is accused of battery, family violence, 2 counts, and criminal trespass from June 3rd of this year. Case number is 25 CR 3152J. Mr. Munaji, you've been advised of your right to remain silent. Your attorney is Ms. Tucker. And this accusation, well, I just came accusation number. Any priors, Mr. Howard?
We all getting old. This is a third arrest. We got 2013 engaging in organized crime activity out of Texas. It was another charge of, I think it was it a burglar of a vehicle or something? But I think they were dismissed. Yeah. 2012 possession of liquor by person under 21. That was dismissed.
Okay. And Ms. Harrison?
Yes, Your Honor. The incident date for this incident is March 3rd, 2025. Officers responded to 25102 Plantation Drive related to a person injured as a result of a fight call. When they arrived, they met with Mr. Olagunju, who stated that he lives at the address with his wife and his wife's cousin at the time, which was the defendant, had just moved into the condo actually 2 days prior to this incident. Mr. Olagunju stated that he works from home. He was seated at the table in the kitchen doing his work on his laptop when the defendant entered the house. The defendant started accusing Mr. Olagunju of entering his bedroom and interfering with his belongings. And Mr. Olagunju informed him that he had not touched any of his belongings or entered into the room, but the defendant kept on accusing him. And while he was sitting, he approached him and told him to get up. When Mr. Olagunju refused to get up, the defendant slammed his laptop shut and proceeded to punch him in his head and upper body area. Mr. Olagunju eventually responded back by punching back and defending himself. And the fight went from that area at the kitchen table into the main kitchen area. And once they ended up in that area, the defendant stopped throwing punches and retreated. And that's when Mr. Olagunju was able to exit the residence and go to the security gate and call police. He also changed his clothing, which was covered in blood. Officers at the scene noticed a chipped front tooth of Mr. Olagunju's and a swollen forehead that corroborated the events that he informed officers had transpired. We did speak to the victim today. He stated that the defendant is his wife's cousin. He confirmed the events in the warrant. He stated that due to this incident, he has suffered over $11,000 in medical bills. Two of his teeth broke, and he had to get surgery to reposition his teeth. He has had almost 15 doctor visits and still has to do more follow-up visits to repair the damage that was caused. He stated that the defendant has moved out of the residence and they have not had contact, but he does not wish to have any contact with the defendant at this time and would like for him to stay away from the residence. Our recommendation in light of the severity of this attack is a $6,000 surety bond. We're asking for $2,000 on each count. No contact at all with the defendant or the defendant's wife. A stay away from the incident location. No drugs, weapons, or alcohol, and a completion of an anger awareness course. And that'll be all for the state. We will sound for Mr. Olagunju in the event that he's joined us in court.
Mr. Olagunju or Ms. Munaji, right? Mr. Toby, if you want to unmute. What's your name, please?
My name is Toby Olagunju.
All right, sir. Would you like, if you want to testify, may I place you under oath? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
I do.
How are you related to Mr. Madison Munaji?
Mr. Minaj is my wife's cousin.
Cousin.
My wife's cousin.
Okay, and who rents or owns the property at was it Plantation Drive?
Right. The property is owned by their grandmother, Melba Fiorentino, but my wife and I have been renting the unit since August of 2024.
So you both on the lease?
No, we're not on the lease, but we had an agreement with the grandmother and Madison's mother about the rental rate that we're going to be paying while staying there.
All right. Mom and grandmother on the phone, on the Zoom? No? Okay. So this couldn't be handled within the family?
I attempted, Judge. I, gave several weeks for Madison to take responsibility and accountability for his actions. And when we ran into each other at the airport, he did not appear remorseful and, in fact, doubled down on his accusation that I had taken something from him.
All right. So has he been back to the house?
From my understanding, he lives there.
He still lives there?
From my understanding, lives there.
So you don't live there anymore?
My wife and I had to move out for our safety.
Oh, okay. So you're not planning to go back to that location?
Not to live, to take things that, maybe mail that's still going there. But otherwise, we don't feel safe being in that community while he still has access to it.
All right. Just explain to me, if he lives there and you have moved out, is your mail now forwarded to your new location or do you
It is.
property there?
Yes, Judge, it is. But I'm sure there are things that might still be mailed there that I haven't accounted for, but I've transferred as much as I can that I remember. I'd like to add, in my attempt I did send all the medical details to him, to Mr. Minaj, explaining.
Your injuries and everything is something you can deal with the prosecutor. I just wanted to know whether you are comfortable having contact with him.
Oh, right. I was just answering your question about attempt to mediate in the family and that I did.
We're past that already. So are you comfortable having contact with him?
No, no, Judge.
All right. And what about your wife?
No, Judge.
Okay, I appreciate it. Thank you, Mr. Olaganju. Ms. Tucker?
Yes, Your Honor. So we're requesting a signature bond for the charge today. Mr. Minaj has a very limited criminal history. So it would be appropriate in this case. He is 30 years of age. He's been in the Atlanta area for over 2 years. The incident location, as it's been stated, it is owned by his grandmother. He has been residing at the location since the incident date. The alleged victims did move. The cousin, his cousin, and the husband, um, they moved out. He's been the only one in the residence. They no longer have access to the condo, from my knowledge. So we are requesting that he still be able to return back to the incident location upon his release, as that is his resident. He has no objection to no further contact with the alleged victims at this time. So we are requesting a signature bond due to his very limited criminal history.
All right, thank you. On count one, battery family violence is going to be 2,500, and that's a surety bond. Count two is going to be a 2,500 signature bond through pretrial level 2. And count three is going to be $1,000 signature bond through pretrial level 2. This is going to be a $6,000 split bond. So if he pays on the 2,500 for count one, then he'll be released, after which he'll need to report to pretrial twice a month. He is to have no further no further contact with Olaf Olaganju and Mrs. and the wife, Miss Munaji. He can return to the Plantation Drive location as long as his mother or grandmother allow him to live there. No illegal drugs, no alcohol, and no weapons and no firearms. He'll be subject to random screens for illegal drugs and alcohol. Within 30 days of being released and reporting to pretrial, he will enroll in a domestic violence intervention program, and he will attend and complete all 26 classes at his expense. If he misses or skips any classes, that would be grounds to revoke his signature bond and have him back in jail. Next court date will be June 17th.
Thank you.
13, Judge, Mr. Robinson.
Okay.
Yo.
Jamal Robinson is accused of willful obstruction of a law enforcement officer from June 3rd of this year, case 25 CR 3154G. Mr. Robinson, you've been advised of your rights, and your attorney is going to be Ms. Tucker. Any priors?
Fifth arrest. We got an arrest out of New York City, driving while ability impaired by consumption of alcohol conviction. 06 possession of stolen property conviction.
Thank you. Mr. Scaropa?
Thank you, Judge. This took place yesterday. Law enforcement was patrolling the area of West Peachtree near 10th in Atlanta when the officer observed a vehicle with a New Jersey plate parked in a lane of travel, unoccupied. GCIC check revealed the registration was expired, vehicle didn't have any insurance, prompting the officer to request a tow truck for that uninsured vehicle. While waiting for that truck, the officer observed two individuals approach and that vehicle, one of them being the defendant, who was approaching the driver's side of the vehicle. When he opened the door, the officer stopped him and asked him to produce his driver's license. He asked why he would have to produce his driver's license. The officer explained that what was going on. The defendant became very upset, stating he always parks there, making insulting comments, and claimed his license was at home when he repeatedly asked was asked to provide it. Defendant continued to refuse to provide his license, walked back to the vehicle as if he were about to get in. When that happened, the officer grabbed the defendant's left arm to detain him. The defendant started resisting, attempting to pull away, tensing up his arm, and continued to disregard the officer's requests to put his hands behind his back, and continuing to attempt to pull away, causing both the officer and the defendant to fall on the sidewalk. The officer could smell the odor of an alcoholic beverage emitting from his breath and clothes. He was positively identified, and with that identification, it showed that his New York driver's license was suspended. He was placed under arrest at that time. The state is asking for a signature bond through pretrial services, no driving without the proper credentials. I feel like that's fair, and no drugs, weapons, or alcohol while out on bond.
Mr. McLean? Oh, Ms. Tucker, excuse me.
Yes, Your Honor. We have no objections to the state's recommendation in this case.
Okay. It's $1,000 surety bond. Next court date is June 17th. No driving unless you have a valid driver's license, adequate insurance, and proper registration. Thank you. I'm not going with the state's recommendation.
Yes, Your Honor.
Got decision 17 next, Mr. Woods.
Mr. Woods? Okay. Cedric Woods is accused of 2 counts of battery, 1 count of simple battery from June 2nd, 2025, case number 25CR 31598. Mr. Woods has been advised of his rights, and his attorney is going to be Ms. Tucker. Any priors, Mr. Howard?
17 on probation out of Fulton, hijacking motor vehicle, computer theft, 22 SC 184-359. I got a hijacking motor vehicle probation for entering auto. Hijacking a motor vehicle, entering auto, possession of a knife or a firearm by a convicted felon, theft by receiving. It's 22 SC 185-484. I got an open case out of Cherokee for trespass and affray. Cobb County, possession of a firearm by a convicted felon or felony first offender.
And that was, I'm sorry, Cobb County?
Correct.
Okay.
Holly Springs, driving without a valid license. 2025 FTA, 2025 probation. 2020 battery DV, trespass DV. That charge was dismissed.
25 FQ. All right. Thank you. Mr. Scirocco?
Thank you, Judge. This took place June 2nd, 2025. Law enforcement responded to 1988 Stanton Road in East Point, which is Stanton Crest Apartments, in reference to a fight call. Upon arrival, the officers found the defendant and a Miss Emile Barber, who explained that she and the defendant were in a verbal altercation. That altercation, she stated, didn't become physical. And while on scene, the officer observed that a male approaching both the defendant and Miss Barber, that was later identified as the victim in this case, Jejuan Barber, Jejuan Barber. Mr. Jejuan Barber yelled aggressively, the officer observed, in a tone stating, "I told you not to F with me," and then removed a knife from his person. Mr. Barber stated he had gotten into a fight with his sister and the defendant in an attempt to defuse the situation, stated that he struck the victim in the face several times with a closed fist. Miss Barber confirmed that her brother had made physical contact with the defendant, pushing him and then hitting him twice in the face. And the defendant admitted that the defendant stated that Mr. Barber pushed him twice, and then he struck Mr. Barber in the face with a closed fist twice. So he admitted to striking the victim here. Although this was a dual arrest, I should mention, Mr. Barber bonded out. The officer observed on Mr. Barber swelling and bruising on his face. and the defendant and the victim were placed under arrest. With respect to history, I just want to make sure I don't believe I heard it mentioned, but on one of his several hijacking motor vehicle convictions, there was a battery charge associated with the 2024 one that he was convicted of. Additionally, I'm not sure if it was mentioned, but there was a riot in the penal institution, interference with government property from 2023 that was ultimately no prost. The battery family violence from 2020, to elaborate on that, it was dismissed due to inability to procure that witness at trial. And there was the separate ag assault from 2016 that I saw. I also saw that he was just released last month after a probation violation. He was released less than a month before we get this case here. Given the defendant's recent multiple felony convictions and prior violent arrests before those, he presents a significant risk of reoffense. Here, the animosity between the two is blatantly apparent and a risk to the community as well. With that and his 2025 FDA that pretrial mentioned, he presents a flight risk. The state's recommendation is an $8,000 total surety bond, $3,000 for each battery charge, $2,000 for the simple battery, a 2-day anger awareness course, no further contact with Judge Juan Barber, stay away from 1988 Stanton Road in East Point, and no drugs, weapons, or alcohol while out on bond.
Ms. Tucker?
Yes. So Mr. Woods is a 23-year-old Atlanta native. He has an education that goes to the 11th grade. He's just recently started new employment at the airport doing as a general technician. So he hasn't currently garnered any income. I think he's been working there for maybe a week or two. He does have children. He has 2 children, a 4-year-old daughter and a newborn son. And considering his financial situation, although he was recently released from being incarcerated, he immediately began looking for employment. He's trying to get himself back on his feet. In this incident, he was not the aggressor. According to him, he was defending himself. He was trying to get back to work to take care of his children. Because of his financial situation, he would not be able to afford an $8,000 surety bond. So we are asking for this lowest possible surety. And if possible, I didn't see any failure to appears on his record. He has ties to the community, family. He's an Atlanta native. We will request a signature bond on his behalf.
I think it was a 2025 FTA, a 2025 probation violation, and he was just released from jail. So each count is going to be 1,000. He's to have so that's a $3,000 surety bond. No further contact with Emil Barber. No further contact with Jejuan Barber. To stay away from 2040 Stanton Road and the entire Stanton Crest Apartments. Once he's released, he is to update the court with his current mailing address, which cannot be the Stanton Crest Apartments. Next court date was June 17th. And as you know, Mr. Woods, you are not allowed to own or possess any firearms. You're also not allowed to carry any weapons, such as what other weapons there may be out there. And
I do apologize, Your Honor. May I request something on his behalf? When the victims, Miss Emil Barbara, the defendant, Mr. Woods, his mother has passed away. Miss Emil is like a mother to him. He's actually been in contact with her since he's been arrested, and he's asked for no further violent contact with the alleged victims. They are like family to him. Even Mr. Barber,
Jejuan?
Yes, both the alleged victims in this case, they're like family. And so he's requesting no further violent contact, but he would like to have contact.
I'm going to allow for no further violent contact with a male barber, but not with Jajuan Barber. But
Okay.
he's required to stay away from the entire Stanton Crest apartment complex. So
Yes,
he'll
Your Honor.
update the court with his new address within 30 days of being released. Courtroom 2, please unmute. Mr. Woods, as you know, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. If you want to waive your right to remain silent, that could be detrimental. So you decide. Or if you want to ask your attorney something.
I wanted to ask my attorney, a question.
So she'll
Do
have,
you want me to call you?
Please call her, put some.
I can give you a call.
all right.
Thank you.
Next court date for Mr. Woods is June 17th.
Day before.
Judge, I got position 16, Mr. Twine.
Okay. We have Amir Smith also today, position 14.
Yes, we do, Judge.
Okay, I didn't know whether there are any waivers or anything like that. Quincy Jarrell Twine is accused of 1 count of battery family violence, 2 counts of simple battery family violence from June 3rd of this year, accusation 25 CR 3158Y. Mr. Twine, you've been advised of your right to remain silent, and your attorney is going to be Ms. Maureen McLeod.
24. On
20
probation for DUI to Douglas County. 2014 simple assault conviction. 2010 simple battery conviction. I start with the 2010.
Okay. Mr. Scirocco? I'm sorry? Still muted. Let's go ahead and see.
Thank you for stopping me while I was ahead. This took place June 3rd, 2025. Law enforcement responded to 2980 Jonesboro Road, Southeast Atlanta, regarding a domestic dispute. Upon arrival, the officer spoke with the victim, Miss Olivia Carter, who explained that the defendant, who is her husband, had become angry after she went through his phone and found something concerning about another woman. She explained that when she confronted the defendant, he responded with BITCH. She went through my phone and then pulled her off the balcony by her hair with both hands. The Miss Carter then advised that the defendant began choking her and standing over her while striking her with a closed right fist. The officer observed that she had a golf ball sized knot located on the left side of her face, and photos were taken of the injury there. And while officers detained the defendant and read him his Miranda rights, he stated he did waive them. He did explain he wanted to answer questions. He admitted he was woken up by Miss Carter regarding her going through his phone and finding something about another woman. He claims he was attacked, and all he did was push her off of him while he was in bed. Miss Carter showed officers a video from the interior camera on the defendant's phone that showed the defendant standing over her, striking her in the face several times. The defendant was arrested. On those convictions, the simple assault, he was arrested originally for a robbery that was Noel Prost. And on the simple battery, there were ag assault, false imprisonment, and cruelty to children charges associated with that case as well. Those were Noel Prost. With respect to his arrests, however, there is a prior battery family violence battery and simple battery arrest from 2011. That was Noel Prost, and an older aggravated assault from 1995 that was dead docketed. We have spoken with the victim in this case. She and the defendant are married. They live together at the incident location. She confirmed they shared no children. And she also confirmed the events in the warrant. She explained that she was sitting down on the balcony when the defendant grabbed her by the hair and then placed both of his hands around her neck and was dragging her in the house. She fortunately was able to breathe during this and didn't feel like she was going to pass out. She explained that there has been physical violence in the past, but police have not been involved up until this most recent incident. She explained she is not in fear of the defendant and wants to continue contact. We take issue with that. We'll be asking for no further contact. She also is fine with the defendant returning to the residence, which we are not okay with. She will be on Zoom, so we would ask the court sound for her when appropriate. Given that this took place only yesterday and involved potential infidelity, there has not been a sufficient cooling off period here. Additionally, with the defendant's extensive history of violent cases and convictions, including a prior battery family violence arrest, and with her explaining to us that this is not the first time he's been violent with her, he presents a significant risk of reoffense to her. As such, the state's recommendation is an $8,000 surety, $4,000 surety on the battery family violence, and $2,000 surety on each of the simple battery family violences. For him to complete FFIP, have no further contact with Miss Olivia Carter, stay away from the 2980 Jonesboro Road, Southeast Atlanta address, and no drugs, weapons, or alcohol while out on bond.
All right. Mrs. Carter, Mrs. Twine, Olivia Carter, if you want to address the court, this is the time to unmute and start your video. All right, Ms. McClellan?
Yes, Your Honor. My client does not have an extensive history of violence. I believe, based on what I heard, the pretrial state, that any history that he has is rather old and were mostly arrests as opposed to convictions. He is 55 years old. It sounds to me like they had a dispute because she obviously breached his privacy. It sounds like he was sleeping and she went to his phone and he became upset. But he denies that he was the primary aggressor in all of this, Your Honor. I would ask the court to consider, if not a signature bond for my client, certainly a much lower bond than what the state is asking for. It appears that his wife is on now and probably she has something to say about this. I was unable to speak to her before now, but I will say that my client tells me that he lives there, that his name is also on the lease, and that they live together and they are married. So I'm going to leave the contact up to the court.
Miss Carter or Miss Twine, how would you like to be addressed?
Either. It doesn't matter.
It doesn't matter? What's your legal name?
Miss Twine.
All right.
Miss Twine.
Could you please raise your right hand? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
I do.
So I've got your screen, your video on the biggest screen I have in my office right now, and it's not. What would you like to tell me? Are you smoking right now? Put your
No.
cigarette out.
No, no, I'm not.
Okay, what would you like to tell me?
Oh, nothing. I didn't have nothing to say.
Really? Nothing to say? Okay.
Mr. Twine knows how I feel. Like I said, we've been talking. I'm not in fear of my life. Like I'm afraid of him, but
This just happened yesterday. When have you been talking?
when he called from jail.
What did he want?
He didn't have no contacts. He was asking me what was going on. He didn't quite understand what was going on, what had happened. And was trying to figure out, pretty much what happened, what was going on, where we gonna go from here.
I see. Okay. Well, if that's all you'd like to tell me, that's perfectly fine too. Please mute your screen. Anything else to add, Ms. McLeod?
No, Your Honor.
Okay. On the battery family violence, that's going to be a $2,500 surety bond. On count 2, simple battery is $2,000 signature bond through pretrial services, level 3. And count 3 is a $2,000 signature bond through pretrial services level 3. His total bond is going to be a $6,500 split bond. Once he posts bond on count 1, then he will be released and he'll be required to report to pretrial once a week, not once a month, but once a week. He's not to consume any illegal drugs, no alcohol, and he's not allowed to own or possess any weapons or firearms, and he will be subject to random screens. Within 30 days of being released, he will enroll in a domestic violence intervention program, and he will attend and complete all 26 classes without missing or skipping them at his expense. Presently, he's to have no further contact with Miss Olivia Carter or Miss Olivia Twine, and he's to stay away from the marital home, which is going to be 2980 Jonesboro Road in Atlanta, Georgia. Once he's released, he's allowed to go back to that location one time only with a police officer to retrieve his belongings, but within 30 days, he must update the court with his new mailing address. If he violates the conditions of his signature bond, the $4,000 portion will also be revoked, and he'll need to pay on that portion as well. Mr. Twine, you are in custody because there is a warrant issued against you that you've allegedly battered your wife on June 3rd, 2025. And I'm very concerned by her appearance. So I'm not here to adjudicate guilt or innocence. I'm just here based on your criminal record history and based on the allegations that you are not allowed to have any contact with her and to stay away from the marital home. If you violate these conditions and it's reported to the authorities, you could end up being back in jail with no bond. Do you understand, sir? Okay. Courtroom 2, please unmute. You have
Mr. Twine, my advice to you would be to remain silent on this. This is concerning your bond. If you have any questions about anything else, you can call me. But I do not want you to comment about what happened between you and your wife.
And please advise him also, Ms. McLeod, that he can't be calling her from the jail because that would be a violation of his bond.
I did already tell him that before, Your Honor, that it would be in his best interest not to speak with her from the jail.
Okay. Thank you. Next court date is June 17th.
Thank you, Your Honor. That concludes my business before the court today. May I be excused?
Yes, Ms. McLeod, you enjoy the rest. What day is today? Wednesday? Okay.
Today is Wednesday, Your Honor.
All right, thank you.
I got position 14, Judge. Mr. Smith.
This is Amir Smith, accused of the following: theft by shoplifting and 3 counts of willful obstruction of an officer from June 3rd, case number 25 CR 3156B. Mr. Smith, you've been advised of your rights. Your attorney is Mr. Tucker, Ms. Tucker, excuse me. And any priors?
Let's see. 7, 2025 probation. 2025 resisting officer conviction was out of state. 2024 theft by receiving conviction. He's on probation for that out of McIntosh County. 2023 loitering prowling conviction. That's it.
Mr. Scirocco?
Thank you, Judge. This incident took place this was yesterday, June 3rd, 2025. Law enforcement responded to 3105 Bethany Bend in Milton. That's the Shell gas station, in reference to a theft by shoplifting that had just occurred. The officer spoke with the reporting party, Mr. Patel Vasudev, who advised that the suspect was a black male wearing a gray sweatshirt and a gray bandana, who was last seen running towards CBS. Upon arrival, the officer observed the defendant matching the description, and as the officer drove toward the defendant to make contact, the defendant ran away from the officer. He ran into the woods behind the CBS, where he was spotted by another officer who gave multiple verbal commands for the defendant to stop running. He ran back to the CVS parking lot where officers were located, and then began to run away again when he saw the officers were there. They made, there were several officers here, three. They all made multiple commands for the defendant to stop running, telling him, it is the police, let me see your hands. The officer caught up to the defendant, who placed his hands in the air and laid down, finally. The reporting party explained that several items were stolen, one drink item and an electronic item from that store, which is the, excuse me, yeah, that's correct. The defendant was placed under arrest at that time. Given the defendant's previous recent conviction for theft, and that was just this January. His recent conviction for resisting an officer, that was also this year. He presents a risk of reoffense here. That with his, what I'm seeing is being a wanted status out of, is it McIntosh County? There was a warrant from his GCIC reflected a warrant issued for probation violation, and that is from May 28th of this year. Given that, state's asking for a $2,000 total surety bond, $500 surety bond for each count here. Stay away from the Shell gas station at 3105 Bethany Bend in Milton, and no drugs, weapons, or alcohol while out on bond.
Ms. Tucker?
We're requesting a signature bond for Mr. Smith. He has resided in the Atlanta metro area for around 7 years. He's 26 years of age. He's just starting new place of employment this upcoming Saturday. He does have one minor child, and his history shows that he does not have any failure to appears. So we are requesting a signature bond because he is likely to reappear for his court date.
Okay. On the theft by shoplifting, that's going to be $80, and that's a cash bond only. On counts 2, 3, and 4, that's going to be $1,000 each, and that's going to be a signature bond through pretrial services level 1. To stay away from the Shell gas station at 3105 Bethany Bend in Alpharetta or Milton, Georgia. No further contact with Mr. Patel, Yashudov Patel. No illegal drugs, no alcohol, no firearms. And next court date will be June 17. So that's a $3,000 and 80 split bond.
Thank you.
Holly?
Yep, you got it.
Yes, sir.
Spurgeon.
Okay. All right.
Next case, please.
I got position 8, Mr. Mitchell.
Daquan Mitchell is accused of 1 count of battery family violence and 1 count of simple battery family violence from June 3rd, 2025, and case number 25 CR 3155E. Mr. Mitchell, you've been advised of your rights. Your attorney is Mr. McLean. And
This is the gentleman's first arrest.
okay. Was there a question about it? Mr. Howard?
Huh?
Any question? This is the first arrest, right?
I got first.
Okay.
So we have as well. Yes, Your Honor. Yesterday, officers were dispatched to 2115 Piedmont Road Northeast, which is the Optimus Lofts apartment, specifically to Unit 3201. A female texted 911 saying her boyfriend choked her and she was in the restroom with the doors locked. When officers arrived at the scene, they gained entry to the apartment complex through the leasing office. Once they arrived at the actual unit 3201, they could hear an outcry of "please help me" from inside. Officers knocked on the door and identified themselves as police. The door opened. They visibly saw a female crying, appearing to be upset, and gave verbal commands to a male that they could see to keep his hands up and walk outside. He was detained without incident, and they identified him as the defendant. The victim here, Miss Erin Usuri, stated that she's been living with her boyfriend. They've been together for approximately 5 years and living together in this unit with her young minor son. This is not the first time that police were called for a dispute, but this would be the first time that an arrest was made. She informed officers that the situation stemmed from a verbal argument that started the night before at approximately 6 p.m. They ended the night, slept together. She got up from the bed and went to finish sleeping on the couch because she couldn't sleep. She woke up at about 8 o'clock in the morning to the defendant um, uh, um, approaching her in the living room and arguing with her. She stated that he started to choke her and began verbally abusing her using profanity. She bit him in an effort to get him off of her, to stop him from choking her. He grabbed her cell phone, but she snatched it back and ran into the bathroom, closed and locked the door, and began to text police. After a little while, she opened the door and she saw him in the kitchen making coffee. And then he proceeded to get back up in her face. And that's when the cops intervened and knocked at the door. The officers did observe redness on the left side of the victim's neck at the scene. We did speak with the victim today. She stated they are in a relationship. They live together at the incident location. They have no children together. She confirmed the events in the warrant, but she states that the defendant grabbed her by her collar of her shirt. She also stated that this is not the first time he's been violent towards her, but it's not the first time police have been called, but it is the first arrest. And she stated that she is in fear of the defendant and she would like no contact. She wants him to stay away from the residence. The state's recommendation in light of these allegations is a $2,000 surety bond. We're asking for no contact at all with the victim, a stay away from the incident location. We will leave a police escort up to the court's discretion, being that the victim is in fear of the defendant. The state's request is no, a complete stay away. No drugs, alcohol, or weapons while out on bond, and we will sound for Miss Usuri at this time. That'll be all for the state, Your Honor.
Erin Usuri, if you're on Zoom and you want to address the court, this is the time to unmute and start your video. Okay, Mr. McLean.
Thank you, Your Honor. I don't have, I have a different address for him. And I 33, well, that can't be the right, that can't be the right zip code. We're off a digit, but I have not a Piedmont Road address for Faulkner. He's 31 years old and he works as a manager at two different stores. One is a shoe store. One is a food store. Prior, in the last 5 years, his work has been warehouse work, Your Honor. But now he's a manager in two stores simultaneously. Given his local ties, the fact that it is his first arrest, he will abide by all court conditions. We would ask the court to consider a signature bond.
What is this place, Faulkner?
The Faulkner Road, I believe that's an apartment complex. Is that an apartment complex? Oh, that's a mailbox, Your Honor. The Faulkner Road is a mailbox.
Oh, okay.
Tell the court where you live.
Currently, I do live there, but seeing the stipulations are that I can't be there, I am willing to move out and move into my cousin's business immediately.
Which is where?
Which is in College Park, Georgia.
Where?
College Park is.
College Park. Okay.
Right, cousin's business. Yeah. Very good.
On the battery family violence, it's 2,500. The simple battery is 1,000. This is a 3,500 signature bond for pretrial services, level 1. He's to have no further contact with Erin Usuri. He's to stay 200 yards away from her and not communicate with her in any way, form, or manner, including person, mail, email, phone, social media, or even a third party. He's also stayed 200 yards away from the Optimist Loft Apartments at 2115 Piedmont Road in Atlanta, Georgia, the entire apartment complex. And he's allowed a one-time visit to the unit which he shared with Ms. Usery. He must go there with a police officer. He must have a police escort, and that visit cannot exceed 1 hour, in which time he would need to retrieve his belongings. No illegal drugs, no alcohol, no weapons, and no firearms. Within 30 days, he must update the court with his new address in writing. And within 30 days, he must enroll in a domestic violence intervention program. These are 26 classes, the entire program, and he would need to enroll, attend, and complete all the classes without missing or skipping them at his expense. His next court date will be sent to his new address, so he'll need to make sure that we have it. Thank you.
You said level 1?
Level 1.
And what was that amount?
2,500 and 1,000, 3,500 total.
Hey, Judge.
Yes, sir.
I have two bond over that's not on our calendar, Mr. Matthew Amato and Brady Love.
Matthew
Brady Love and Matthew Amato.
Amato was NOD'd
Okay.
on all charges.
Do you know about Brady Love?
I'm not sure about that one, but I'm looking for Mr. Farley, Samuel Farley.
He waived his appearance in court, position 3.
Okay, who's representing Mr. Farley?
Your Honor, I will waive his presence.
Okay, and what about position 12, Obehi Peters?
That's an MH reset, Judge.
All right. So position 12 is an MH reset. Who was originally going to represent him? Mr. McLean, was that you or Ms. Tucker?
I'd have to look, Your Honor. I've got it. I've got the split sheet here somewhere.
Okay.
You said for Mr. Peters?
Yes, Obehi Peters. Was that you, Ms. Tucker?
No, I believe that one was conflicted.
That was a conflict, Your Honor.
Oh dear. Okay. We'll reset him to the C calendar tomorrow, June 5th. And hopefully someone will confer or have a social worker visit to determine whether he needs to be reset to the 11 a.m. calendar. All right. So in the meantime, we have Samuel Farley, and Mr. Farley appearance has been waived. He's got case 25 CR 3160C, accused of battery, family violence, criminal trespass, and simple battery from May 10th, 2025. Mr. Farley, how many cycles does he have, Mr. Howard?
9.
9, okay. Based currently on his open felony cases, Mr. McLean, that's going to be 25 PI 004394, 25 PI 004393. He's got a DeKalb County hold as well.
And that's robbery.
Okay.
You know, which case are we dealing with here on this calendar?
Yeah, Samuel Farley, position number 3. You waived his appearance?
Right, what's the case number?
The case number is 25 CR 3160C.
3160C. Thank you.
Position 3, battery, family violence, criminal trespass, and simple battery. Anything else to add, Mr. Howard?
No.
Okay. Ms. Harrison, what's the state's recommendation?
Your Honor, the state's recommendation is a $3,000 surety bond, a stay away from the incident location, no drugs, weapons, or alcohol while out on bond, and no further violent contact with the victim. And I'll give you a brief rundown of the facts because I believe our victim has joined us in court. This incident occurred on May 10th, 2025. Officers were dispatched to 55 Milton Avenue in regards to physical disturbance. They met with Ms. Nevaeh Williams, who stated she was contacted by her brother, the defendant, who was going to come over to retrieve some items from her home that he'd left there when he was previously living there. He arrived around 3:30. She allowed him inside. He began to rummage through her closet. And she advised him that he had no business in her closet because none of his belongings were in there. A verbal dispute began, and that dispute turned physical when Mr. Farley bumped into Miss Williams with his 65-inch TV as he was walking out the door. And she was holding the door for him. So when he bumped into her with the TV, she pushed him and the altercation ensued. And the defendant grabbed Miss Williams by her arms and slammed her on the ground and pinned her down inside of the closet. He let her go shortly afterwards. Another verbal dispute broke out again, and Mr. Farley picked up a glass candle and threw it at Miss Williams' TV, causing the TV to be damaged. And officers were able to observe the bruising to Miss Williams' arm, and there was also a witness on the scene who observed the entire altercation, including her being pinned down in the closet and the TV being broken. We spoke to Miss Williams today. She stated that she is the sibling of the defendant. They do not live together. She confirmed the events in the warrant and stated nothing like this has happened before. She stated that the total cost of the TV is about $250, and she has not seen or spoken to her brother since this incident. She's okay with further contact as long as it's not violent contact, and she would like him to stay away from her residence. And I'd like to sound for Ms. Williams at this time, Your Honor.
Nevaeh Williams, if you'd like to address the court, this is the time to unmute and start your video. All right, Mr. McLean.
Your Honor, considering what we've heard, we would ask the court to consider a $1,000 surety bond. Thank you.
On count one, battery family violence, that's going to be a $2,000 surety. Count two is a $500 surety. Count three is a $500 surety. The total is a $3,000 surety bond. No further contact with Nevaeh Williams. I'm sorry, no further violent contact with Nevaeh Williams, but he must stay 200 yards away from 55 Milton Avenue in Southeast Atlanta. No illegal drugs, no alcohol, no weapons, and his case will be reset to June 17. Thank you. All right, just to go down the calendar. Is it number one? Yes, sir.
Mr. Brady Love gonna be a reset. I do have him present.
Brady Love, is that the bind over?
One of the bond overs, yes.
Okay, do we have a booking number?
I do, Judge. That's gonna be 251-0104.
Give me a moment.
Yeah, me too.
All right, Mr. Brady Love is a bind over. He's got a $2,500 surety bond.
Battery. Ooh.
I cannot view any of the documents that was submitted. Can you, Miss Harrison?
I'm opening.
I was just checking, Judge, and I can't view them either.
Yeah, I'm opening up that tab now, and I don't think so. 3.
If he has got a bind over, he's already got a bond, and I can go ahead and reset him to the SAP calendar on June 17. Is this a conflict case?
It is not a conflict case. I have the information that I'd like to share.
Okay, he's charged with battery, but it's not been accused, and he's already got a bond, so there's no Riverside issue. He's already had first appearance at whichever court he came from where the bond was established.
Right. There's a medical situation with him I'd like to share.
I see. Okay.
This is not a mental health situation. It's just physical medical information, so it's not embarrassing. I don't need a breakout. He's going blind in his right eye. About a year and a half ago, he fell out at work, and he's been disabled ever since. The falling out at work, so to speak. is congestive heart failure. His heart was at 20% at that time. They've been giving him medicines to try to improve that 20%, but he's a mess. Prior to becoming disabled, he worked in a warehouse. And after that, the work at which this happened, he was working for a city government locally at the Parks and Recreation Department. It's physical labor. We'd asked the court, since this happened, this is alleged to have occurred in November of 2023, and his medical condition is what it is now. We would ask the court to consider a signature bond or a $1,000 surety bond.
Judge, we would request that the bond remain as said. We know nothing about this case, about the defendant's history, and we just have no information. This was kind of just thrust on us within the past couple of minutes. Without that, we request this remain set and that this be dealt with at SAP.
All right. Mr. Scirocco, I think your office is going to accuse this case, so please get it accused by tomorrow's C calendar. Bond is going to be modified to a $1,500 surety bond. Given the age of the case, no further contact with the victim, stay away from the incident location, no illegal drugs and alcohol, and we will address this matter tomorrow once we get his criminal record history to see if Judge Morrow will further reconsider the matter. So we will reset it to the C calendar tomorrow, pending an accusation to be filed by the Solicitor General's office.
Okay.
And Ms. Bridgewater, you can use his jailing number as a reference right now to modify the bond to 1,500 surety.
Your Honor, give me that booking number again, please.
251
Uh-huh.
0104.
Okay, and the bond is going to be amended to a 1,500?
Surety bond.
Okay.
And reset to the C calendar tomorrow, pending accusation. And if we have his GCIC, Judge Morrow can further amend it if required.
Okay.
I got it now. You want it? Or you want to wait?
I want to wait because I don't have an accusation.
Okay.
No, thank you.
Your Honor, I had a client that I had interviewed, but I don't recall her appearing. DeJazel Davy.
Repeat the name?
DeJazel Davy.
Davy.
Davie.
She was NOD'd on all charges.
Okay. Thank you.
All right. So we good, Deputy?
We're good, Judge.
All right. So giving the calendar, position number 1, Autumn Beatty was a $1,000 surety bond, reset June 17th with a social worker visit. Ms. McLeod, that's Mr. McLean's client. Position 2, Davia is a 2,500 signature bond through pretrial, level 1, further notice. Position 3, Farley is a $3,000 surety bond, reset June 17th. Position 4, Haddock is a $1,000 surety, June 17th. 5, Hepburger is a 2,500 signature bond through pretrial level 1. Position 6 is going to be a 2,500 surety bond, reset date June 17th. Position 7, Laney is a 2,500 surety, reset June 17th. Position 8, Mitchell is a 3,500 signature bond through pretrial level 1 with DVIP. Position 9, Munaji is a $6,000 split bond with 3,500 being a signature bond through pretrial level 2. 10, Ochoa is a 2,500 signature bond through pretrial level 1. 11, Parker is a $1,000 surety bond, reset date June 17th. 12, Peters is reset to June 5th, pending a social worker visit or recommendation to go on the competency calendar. 13, Jamel Robinson's a $1,000 surety, reset date is June 17th. 14, Amir Smith is going to be a 3,000 signature bond through pretrial level 1 and an $80 cash bond. It's a split bond, reset date is June 17th. Henry Thomas is a $5,000 signature bond through the jail. Position 16 is going to be $6,500 split bond, with $2,500 being surety and the remainder being a signature bond through pretrial level 3, reset date June 17. Cedric Woods is a $3,000 surety bond, reset date June 17th. Mr. Brady Love bond has been amended to 1,500 surety and reset date to June 5th pending accusation. Did I address anything else over and above these cases? No? Okay.
I think you covered it, Judge. Could I just request very briefly if for whatever reason, I'm not sure who necessarily deals with this on the jailing side, but it's whatever documentation for Brady Love exists, it's unavailable. I could just ask that that be made available in jailing.
You got to call records.
Records. Okay.
Records
Thank you.
or booking. Yeah, because I didn't see where they upload this information either.
Okay. Thank you.
Deputy 402. Yeah, is records on Zoom? No. Or Miss Grace, or Miss Grace, is there a way you can contact records to ask them to allow access to Mr. Brady Love's documents so that the state can accuse the case if they want to?
I'm gonna do that, Judge Law. I'm gonna do that.
Okay.
Okay, Sheila.
Okay. Oh, great.
Okay. All right, everyone. Have a good afternoon.
Your Honor, I'll join that motion and ask that the same police report be sent to me. Thank you.
Oh, this is the access on Odyssey. Do you have that?
I do have Odyssey, yes.
Okay, so what's happening is that when we try to click on Mr. Brady Love's documents, it just says you're not authorized to view the document. So it's been locked by whoever uploaded it.
I believe the same would be true for me, so I need somebody to email it to me, I suppose.
No, we're going to unlock it so that it can be accessed by individuals who have access to Odyssey.
Very good.
Okay.
Your Honor, can also some type of draft be done for your signature for Mr. Love?
I just need a bond order.
Okay.
That's all. Just a standard bond order that you've got
Okay.
with the jailing number on it. That's all.
Okay.
Then tomorrow, if they accuse it, we'll just amend the bond order to
Okay.
add accusation and any changes.
Okay. I'll send that to you.
All right, folks. Last call. Have a great afternoon.
Thank you. Have a good day.
Bye, all. Have a
Okay.
good one.
Bye.
Bye.